Righty-ho. Well, I think we've got a few people who have managed to join us, and a few people obviously still making their way into the webinar, but we'll get things rolling. And if anyone joins a couple of minutes late, then I'm sure they won't have missed all that much. But thank you very much, everyone, for joining us for today's latest installment in the series of housing law webinars on our kind of how-to guide, some of the practical elements, trying to demystify some of the processes where lawyers can add a little bit of insight into your everyday working experiences. Just as to confirm, below there's a little message from our very helpful marketing and business development hosts. Just to confirm that this webinar is being recorded, and so the recording should be available after the event, all being well. If you do have any questions, then we've got a Q&A function, and we'll do our absolute best to answer any queries that you might have. We'll try and leave some time at the very end to deal with those queries. If there's any points that we need to come back to you on, we'll also do our best to do that too. Anyway, so we are going to be, so in terms of today's session, just introduce myself very briefly. My name is Lachlan McLean. I'm a partner in the Housing and Regeneration Litigation Department, and solicitor advocate. I've been doing antisocial behaviour litigation for over 15 years. And as part of the work I've done over many years, it's involved helping clients to liaise and get information from other agencies, including the police, social services, medical practitioners, and so on. It's a situation which is obviously of very great importance. I appreciate to many of you working in social housing, whether you're acting for the housing provider or a local authority or some other agency. And I'll be joined today by Dan Mills, who's going to very knowledgeable individual on the subject of data protection. I know Daniel, don't do yourself down, Dan. And for what it's worth, he's also our firm's data protection officer. So if you ever have any queries about that, they'll probably end up coming under his desk as well. Dan's also, I'll let you introduce it, say a few words about yourself in due course, Dan. But before we do, I'll just share my screen so that we can see our usual disclaimers that we are obliged to share with you. So hopefully you'll be able to see that okay. And I'm going to turn my video feed off just to try and reduce the bandwidth a little bit as well. So hopefully you can all see that well enough. Just to confirm, as the title of our session today, liaising with partner agencies, and Dan will heartily approve, obviously being involved in our compliance management to make sure that you're all aware that we're obviously going to try and deal with general topics today. If you have any very specific questions requiring legal advice, I'm always happy to help with those. Might not be able to give you a detailed answer today, but hopefully you'll find the materials useful for in improving your knowledge and awareness in this area. So without further ado, I might hand over to Dan, who's going to kick us off with a bit of introduction on the legal framework around this area.
Fantastic. Thank you, Lachlan, for that very kind introduction, and good morning, everybody. I won't dwell too much. I've been with the firm for ages, so I've done a variety of different things, but I think I'm on my third round of data protection legislation at the moment after the 84 and 98 version. So the 2018 version is, we still call it the new one, although it's fairly well bedded in by now. We do encounter in working with our housing litigation colleagues and clients a lot of questions about data sharing, the appropriate use of information. And I think Lachlan's hit the nail on the head. What we're looking to do today is help you with the day-to-day issues you have to deal with in your working practice, with a view to helping you get done what you need to do more effectively. And let's keep that goal-orientated approach in mind, because it's extremely easy to get bogged down in data protection. It happens to me all the time because people keep dragging me back into it, however hard I try. Hopefully what we're going to talk about in the first part of today's webinar is some fairly clear principles that you can apply. And if you stay on the right side of them, then all being well, most of the time, you should be able to get done the things you want to. It is relatively rare that we find a situation where the data protection legislation actually prevents somebody from doing the right thing. So with that optimistic goal in mind, let's press on and see how we do. So what are the common issues with data sharing that we find? There's a reluctance to share with other organizations. And well, that arises often because there's a concern about committing a data breach, which is a bad enough thing in itself. But what that really translates to is a concern about being fined by the Information Commissioner's Office and or being sued by somebody whose information you've given out when they say you shouldn't have done. We will come very shortly to why that is a lot harder for people to do than you might imagine, because a lot of people share a common misconception about data protection, which is that you have to have consent for everything, and you absolutely don't. So if you take nothing else away from this section today, it's never about consent most of the time. There's also difficulties getting the information you need from other organizations because they may have similar concerns on their side and they may not understand how data sharing works. The important thing to say is data sharing is definitely a thing. There is data sharing guidance published by the ICO, which I will be referring to a little bit later on. So the regulator is well aware that organizations need to share data and has got the guidance out there on how to do it. And I'll stress that point when we come back to it later. The ICO's guidance is in terms of how to do it. It is not in terms of don't do it. And it isn't in terms of what they're going to do to you if you do it. It's about, of course, you're going to share information because how would you not? Therefore, here's how we do it correctly. So next slide, please, Lachlan. So why would you want to bother about data sharing? What we tend to come across, and certainly I know with ASB cases on which I've been involved, sometimes not all the evidence is in the same place. So you might be the party that needs to go off to court, but you may not have all of the information. Some of it may be with the police, some of it may be with local authorities, some of it may be with health. And you need to get that information in because you need to make use of that evidence. Alternatively, you know exactly what's going on, but what you need doing is something that only the police or the local authority has the legal power to do. So you need them essentially to pick up and take the thing forward effectively on your behalf using the information you have. The other reason for data sharing is to avoid the horrible baby P type problem of missing the big picture. Having a situation where lots of different organizations know there's something wrong, but only afterwards, when you get the serious case review, is all that information pooled and suddenly the appalling truth is evident to everybody. So there have been cases of that nature, and it is a legitimate objective to want to avoid that happening on your watch. So lots of good and legitimate reasons as to why you might want to go about do some data sharing. So next slide, please, Lachlan. How are we going to go about it? Well, there are three fundamental elements. There's knowing how the Data Protection Act and the UK GDPR are set up in order that you can navigate your way through them. There is the ICO's guidance, which, as I mentioned earlier and we'll come back to later, is about how to do it, not that you shouldn't do it. And then there's some fairly simple best practice, and that helps you stay on the right side of the terms and conditions that come with the legislation and the ICO guidance. But fundamentally, for anyone who hasn't seen this classic Spike Lee film, number one, go see it if you get the opportunity, but do the right thing. It is important to bear in mind that this is how the data protection legislation works. It is not a long enough bit of legislation to describe how everybody should manage all the information with which they deal. What it does is set out the principles. And the whole point of how data protection works is if you have a good enough reason for wanting to do something with somebody's information, the legislation normally lets you do it. It might ask you to be careful about how you do it and to think twice before you do it, but it certainly gives you a way to do it. So the key thing is have your purpose firmly in mind, because that effectively then is the passport into the permissive elements of the legislation that let you do data sharing. So next slide, please. Let's get into that first section of how to make use of the legislation. So you don't always get a Joe Strummer quote in, but we'll see what we can do. You need to know your rights. And this is where you need to be able to take a firm position. And if somebody's telling you, we can't share that information with you, or you couldn't do that with my information, I'm going to sue you for it. You need to know when you can say, that isn't correct. We did have the ability to do that. We have gone about this in the right way. You may wish we hadn't done it, but that isn't the be all and end all here. We had an obligation, we discharged it. So let's look at how sharing works with the data protection legislation. Quick check as to just think, do we have a hand go up there? I am just checking what we have. Is there anything going on in the chat? We're okay at the moment. I will press on for now, but if there is anything, please do lump it into the Q&A and we will pick it up. So does the DPA make you share information? No, it doesn't. There's nothing in the DPA that says you, or the GDPR that says you have to. It simply says that you can. Now, what it does do, and this is where we have a connection to the section that Lachlan's bringing in later about working within litigation proceedings, it does acknowledge that other parties may be requiring you to share information. And what the data protection legislation does is understand the existence of that other compulsion and recognize that you may have to go along with it in undertaking your proper function. So it's generally permissive rather than prohibitive. So it talks about, in order to process, you need to be able to. And then it's as long as you can tick off the things in the list, you can carry on. So what you need to do is sharing like tangoing needs two. So what you have to understand is, if you're going to be doing some sharing, understand what is the basis on which the other party is asking you to share. Now, if the other party is asking you to share because they're asking you nicely, that's okay. You might still be able to. If the other organization is telling you, then that puts you in a different category of compliance, because something bad will happen to you if you don't share the information. So you may not have 100% freedom of choice in all situations. But in many cases, it is your decision to make. So what you need to be doing then is thinking about, how are you going to make that decision? So if we can go to the next slide, please. The thing to bear in mind here is, if you are the data controller, so in the jargon, it's not an individual person, that's the organization. So in this case, let's say the housing association or the local authority with a housing function. Whatever happens to the information you are holding is on you as an organization. So hence the quote, you can always choose, but you should know that if you don't choose, you're still making a choice. So whether you choose to pass on the information or you choose not to, you've made a choice either way. So what you can't do is say, well, procedure appeared to require that I needed this, or I gave it out because somebody asked me for it. You've got to be a good existentialist, as Sartre would have required, and you've got to make your own decisions. So what you can't do as a data controller is abdicate your responsibility for it and say, well, we didn't think it was our decision to make. Share it, don't share it, always your call. But in most cases, you probably can if you really want to. So if we can go to the next slide, please. So how do you make that decision? Well, you shouldn't, as an organization, really have individual people having to remake that decision on a daily basis. What you really want to be having is policies and procedures in the organization about the circumstances in which, as an organization, you do endorse data sharing and the situations in which you generally don't. As with any good policy, there's usually an override or a get out if you do it properly, but that isn't something that people dealing with this in a frontline situation should have to worry about. They should be able to apply the policy with the ability then to refer the question up if that doesn't solve the situation in which they find themselves. So you've got your policies, you've got your procedures. And procedure is equally important because that will tell you the sequencing and the timing and the preconditions that you need to have in place. So the policy may be that we do it. The procedure is about how do we do it. So it's equally important to have both. So you know when to say yes and when to say no, and you know how to proceed if you're saying yes. So as an organization, you have objectives and values. You will have made various commitments to your tenants, other stakeholders, communities, funders, all kinds of people with whom you deal. And you've got the organization's values, you've got the charitable objects that are usually underlying most housing providers. So those can be there as a bit of a backup. And if it comes to it as an individual, you have got that professional judgment. And Lachlan, I'm sure, would agree, having dealt with hundreds of people working in the housing sphere over the years, there is that professional judgment. There is that ability to say, this may not yet have got to the point where we would normally start data sharing, but as soon as X, Y, or Z happens, then absolutely our procedure will swing in and we'll be right behind it. So sometimes you might have to make a decision about exactly how does our policy or procedure apply in this case. But again, bear in mind, looking to do the right thing and getting to the right position you want to be in. So let's have a little talk about what the GDPR says about how you do processing. So next slide, please. So lawful processing, and I'll mention this in a few slides' time. Data protection principle 1, processing will be fair, lawful, and transparent. So let's talk about fairness. The number one point to make here is use of a third party's personal data does not require their consent. In the context of social housing, it almost never requires their consent. What do you need consent for? Broadly speaking, marketing. So, okay, newsletters, marketing, special offers, that sort of thing, fine. Pretty much everything else, it's either performance of the contract, which is the tenancy, or it's discharge of a public function, or it's something of that nature. So in Article 6 of the UK GDPR, we find the grounds for processing normal personal data, and there are A, B, C, D, E, F, G, H, 8 of these, and only one of them is consent. It's misleading that consent is the first thing in the list because the ICO itself, as the regulator, says it's the last thing you should try to rely on for processing personal data because consent can be withdrawn. So if you have asked for somebody's consent to use their information, what are you going to do if they change their mind? If the answer is, we can't go back on it, then in theory, you probably didn't need their consent to begin with, and it may have been a mistake to have sought it. So let's have a look at what the other available grounds are. Compliance with a legal obligation to which the controller is subject. Well, there you are. If you are under a legal obligation to perform a particular function, then you have to do it. You don't have the choice. So if using the personal data is necessary, sharing it is necessary in that context, then so be it. Bear in mind, all of these processing grounds are prefaced by the word necessary. And because this is originally European-based legislation, that necessary is important and can really be understood as being there is no other way. And that lines up very nicely, actually, with the other data protection principles that I'll mention in a moment. If there's an easier way that doesn't involve sharing the personal information, then do that instead. Fine. We need to be in a situation here where you simply cannot do the thing you need to do without sharing the information. So number 2, protect the vital interests of the data subject or another person. So I may have to share information about person A in order to protect person B. And if you're thinking of domestic abuse or you're thinking of ASB, then you are often giving information about person A to prevent them doing something bad to person B. And that's absolutely fine. Yeah, it's not going to do person A any good because potentially we're going to end up with person A being injuncted or arrested or evicted or whatever they might be. But the fact that there are adverse consequences for the person whose information you share does not mean you can't do it. It does mean you want to be careful about it, but you want to be careful about anything involving data protection anyway. And finally, the sweeper, performance of a task carried out in the public interest or the exercise of official authority. This is the public sector version of the legitimate interests processing ground that you often hear mentioned. But given that for a variety of reasons that Lachlan and I could talk to you about at great length but won't today, a housing association is sometimes a public body and sometimes not, I'm going to give you the public body version here. If you're having a day when you're not a public body, then you can apply the legitimate interest ground, which is very similar. So that's ordinary personal data. Next slide, please. Let's take a look now at special category information, and you can still share special category information. So quick recap, what special category? In this context, it would include health information. It might include information about a person's sex life or sexual preference. The list includes a variety of things, including trade union membership and lots of other exciting things that may not be relevant here, but it would include almost anything you can discriminate against somebody about. So a wide variety of information could potentially be caught by this. So this is covered by Regulation 9 in the UK GDPR, and there are a wider selection of processing grounds, but they are more narrowly defined. This is the more regulated category of information. You can do a lot more harm to somebody with this kind of information, is the thinking behind how the legislation is set up. So how can you process special category information? By sharing it. Well, you can do it to protect the vital interests of this person or another, but only in this situation where the data subject is physically or legally incapable of giving consent. So you might imagine in this scenario a situation where somebody is lacking mental capacity. So if they are lacking mental capacity to be involved in legal proceedings or to enter into a tenancy agreement or any of the things where that would make a difference, realistically, are they in a position to give you legally binding explicit consent to share their data? Probably not. If you've got somebody who is in such a bad way health-wise that you are having to call in help for them, you may have a situation where they literally cannot help themselves. And you may have somebody, as we have done in other cases, who says, I do not want a social services assessment, but everybody else is saying this person lacks mental capacity. So yes, they're not consenting, but in truth, do they understand what they're saying no to? So if you've got somebody who is that far down the track, you may be in a situation where you can say, this is in this person's best interest, if this is really serious. And vital interest isn't necessarily just life or death, but it's towards that end of the spectrum. Although sadly, we know that is often the case in the social housing field. We've then got establishment, exercise or defence of legal claims. Excellent news. If we're in court or we're heading to court or we're getting ready to go to court, then we can share that information where it is necessary for that purpose. So sharing it with the legal team, sharing it with witnesses, sharing it with the court, that sort of thing, permitted. And reasons of substantial public interest. So not the one you necessarily want to go to all the time, but it's there in the background, and sometimes it might be the appropriate basis for lawful processing. So next slide, please. Because the third category we have is criminal convictions and offences. So this used to be, under the old data protection legislation, part of what's now special category information, or sensitive personal data as it used to be called. Nowadays, it's got its own bit in the Act and its own bit in the UK GDPR, Section 10 and Regulation 10, and Section 11 and Schedule 1, the long and the short of which is you can share information about criminal convictions and offences, which, because of Section 11, includes proceedings intended to convict somebody or investigations in relation to criminal offences. So the precursors, not just the convictions. And you can share this information, you can process it for the purpose of preventing or detecting unlawful acts, preventing fraud, preventing an individual who is vulnerable from neglect, physical, mental or emotional harm, and once again, legal proceedings. So it goes without saying, but this is where the legal basis of it would be. If you're taking for example, possession proceedings against somebody on the basis that they have been convicted of something which creates that ability to seek possession, then you need to prove that conviction exists. So you can, of course, disclose the existence of that conviction if you have the information to hand. There is a little asterisk there. Terms and conditions do apply. Some of these grounds for processing have additional conditions you need to meet, such as substantial public interest test, and also in some circumstances demonstrating that you have an appropriate procedure for dealing with that particular sensitive information. But it can be done. I think that's the important thing. So there are other principles we need to bear in mind. So next slide, please. Thanks, Lachlan. So apply the principle. So principle 1 is where we have been for the last few slides: lawful, fair, and transparent processing. So in order for it to be lawful, you need to have a valid ground for processing, being one of the ones we talked about. There could be exemptions applicable which switch off some of those requirements in certain circumstances, such as the legal proceedings situation. And don't forget your privacy notices, because these are the things that you have out there, rather like the small print disclaimer that Lachlan showed you earlier. You get it out at the start of the tenancy relationship and explain to the person, for so long as you're one of our tenants, and indeed afterwards, we might have to give your information to third parties, and that might include long list of parties here. We've written a few of these for RPs over the years, and the list of people with whom you might have to share that information keeps on growing. But the point of the privacy notice is it is the answer to the transparency requirement. If you've told the person that you might do it up front, you still don't need their consent, but you did tell them it might happen. And that is an important part of the compliance approach. There are other principles. There are 4 other principles, well, 5 if you count the accountability principle. And other principles here include a purpose limitation. So if you are processing information, and in this context, sharing it is one example of processing, and you do that for a purpose, then that is the only purpose you should be doing it for. And you can't change purpose without effectively going back to square one and saying, is it actually okay to share this information for this other purpose as well? So if, for example, we're sharing information with another organization to protect the vital interests of somebody who's at risk of serious violence, that's not quite the same as the same information then being used to persecute somebody for non-payment of the council tax, for example. If we've got over that high immediate danger threshold to do the initial sharing, it doesn't then mean it should be open season for the recipient organization to use that data for any other purpose they might have in mind. So stick to your original purpose. The accuracy principle. The information you share should be accurate, because you can do a lot of damage by sharing inaccurate information. So if you're going to share information, it should be up to date. It should be subject to appropriate data hygiene and routine checking, etc. If you go back to your tenancy management system and drag out some records from years and years ago without checking them, send them out, they might be used to produce a result that actually shouldn't be happening. So is that information current? Is it accurate? You've then got the data minimization principle. You should only process, so in this case share, as much information as is necessary. So right now, what's happening to affect a particular tenant, you may only need recent information. You may not need, for example, to send the entire housing file. It may be this person's led a blameless life for 10 years and it's all just gone to pot now. Well, in the majority of cases, the previous years aren't that relevant here. It's what's going on at the moment that's causing the problem. So think about the extent of the information you need. And then you've got the information security principle. And this is information in transit, in use, and at rest. So if there is a legitimate reason to share the information, what you shouldn't do is then share it in a careless manner such that you commit a data breach in the act of sharing. So the classic example here would be you get together the information and you send it to the wrong email address. So it ends up out there in the world somewhere, and it could have criminal records information in, it could have special category information. It could be the kind of information that really shouldn't be out there on general release, and you should have shared it more carefully. So in this situation, we're thinking encrypted email, we're thinking courier delivery rather than general postage. Ideally, we're not really going hard copy at all, given half the chance. And just thinking about the mechanism and the method you use to go about the sharing. And then finally, you've got the accountability principle, which requires you to demonstrate that you have in place effectively a compliance system for dealing with personal information. So provided you've got that kind of policy and procedure I mentioned earlier, you should be able to meet that test. So next slide, please. So that's part one of our 3 ways to do data sharing appropriately. Step 2, follow the guidance of the ICO. Now, the good news here is there's a good reason for wanting to know what the ICO says. So let's take a look at the next slide, please. Why do we care what the ICO thinks? Well, it is the regulator in this section and this area of operation, and it is also the prosecuting authority. So if anybody's getting fined under the Data Protection Act, they're getting fined by the ICO. And for anybody who is located in the Northwest, unusually for a government body, at least until the North Shoring really got going, the ICO is based in Wilmslow. So actually, various of its staff might be driving past your offices on their way to work. So you're not a million miles away if they want to drop in if you're based up in the Northwest. That said, they get around. So it doesn't matter if you're not. The ICO can still come and find you. They do have searching powers. They do have investigatory powers. And as you are aware, they can levy some pretty chunky fines, in that the maximum fine went up in 2018 from $500,000 to about 14 million, and potentially higher if you have a big enough turnover. And there, having done a little bit of maths in my head, I think there are some RPs who might just have enough group turnover to go into the higher level of percentage-based fining. So having said all of that, what does the ICO say about data sharing in your particular field? Well, I'm not going to go into the detail of it today because we only have a limited period of time. But what I have done is extract some statements here from different bits of ICO guidance to hopefully give you some reassurance that what the ICO wants is for data sharing to happen when it is appropriate and to be done properly. The ICO is not out there clamping down on data sharing. The ICO knows that you have to do it, and its concern is that you should do it correctly. So, for example, be clear about why you need criminal offence data. Most of the conditions are based on the purpose of the processing. Echoing what we said earlier, if you know why you need to share the information, then that is what leads you to find the correct part of the legislation that gives you that ability. There's a section called How to Share Information Collected for Law Enforcement Purposes with another organisation, so it can be used for non-law enforcement purposes, i.e., when can the police give you information that you can then use in civil proceedings? Well, they can, because there's a whole guidance section on how to do it. There's a section called Practical Advice on the data protection considerations when you need to share personal information for child safeguarding purposes. And I'm probably not the only school governor on this webinar. Safeguarding is everybody's business, because I've done my safeguarding training for the year quite recently. Of course you disclose safeguarding concerns. That's the point. Untold harm comes from sitting on them and doing nothing. So the whole point of it is about information sharing and appropriate action. And the UK GDPR does not prevent sharing personal data with law enforcement authorities. So there it is, word for word from the ICO. Of course you can share information with the police, with local authorities, with border agency, with whomsoever it may be. So you absolutely can. It's very much a matter of what's the right way to go about it. So with that in mind, let's move on to our third section, which is the use of best practice. So next slide, please, Lachlan. So this is about best practice end to end throughout your process. Your best practice does not start when you want to do a particular instance of sharing or when you get a request for sharing. It should have started already, in that you should already have the policies and the procedures. You should know by and large, the organizations with whom you may want to do data sharing. And off the top of my head, I'm thinking that'll be the police, that'll be social services, that'll be health providers, could be others, could be other stakeholder organizations with which you work, could be joint venture partners, could be contractors. If you've got gas people, for example, trying to get access and you need to show them the red flag list of when they should always turn up with two big guys in a van in order to access a particular property, or turn up with some dog treats, that sort of thing. Absolutely fine, perfectly legitimate to do that. But what you should be able to do is identify, who do I want to share with? How am I going to do it? And get that in writing. All joking aside, what that small print that Lachlan put up at the start showed you was how you do data sharing. Get it down in writing up front, and then do what you said you were going to do. And that sets you on the right path. So in a written agreement for data sharing, explain the purpose, understand that, assign responsibility for determining when the sharing is required, how long it goes on, what will happen to the information when it's there. Keep it under review. Circumstances change. Arrangements may become obsolete. Technology can move on. The organization of local authority functions, etc., can change. And reflect that in your compliance documents, and I'm particularly thinking here privacy notices. So then, once you've got that, manage your data sharing carefully. Do your transfers safely. Don't stick it in a second-class envelope with a weak seal on it. Don't bang it out in an unencrypted email. Really don't fax it. I did hear a little while ago about one local authority safeguarding department that did still want to be notified by fax, and hopefully they have moved on a bit. Safe storage on both ends. So you need to know that if you're going to share information under these strict regulations, that the recipient organization is not going then to put it on a landfill or leave it lying around somewhere, or generally make it more visible than it should be. How long are they going to keep it? Because if it's been shared by you, you need to know when you let go of it, how long is that copy going to be out there for? What's the purpose? Are there secondary purposes in mind that you know are so common that you can build them in? And then the other key thing is relationship management. It would be riding a very tall horse indeed on behalf of any lawyer to say, get it in writing and that's all you need. It's not all you need. You need a working relationship with your points of contact in those other organizations. You need somebody with whom you can have that conversation where you say, we normally share, but it really doesn't sound like we need to on this occasion. Why are you asking? We don't get why you're asking in this situation. What has changed? Or why are we doing this outside the usual process? We have that for a reason. So get that in writing, understand it, keep the relationship on an even keel. So finally in my section, of course, we will turn to the guru of data protection, George Michael. Who else? And in summary, if you're going to do it right. So there's the summary. If you're going to do it, you often have a choice. Are we going to share? Do we have a good reason? Do we have a process? Great. Or then don't drop the ball at the last minute. Follow through, do it safely. Don't start a problem where there doesn't need to be one. And that is how you can do your data sharing and get your jobs done. So I will pass you back to Lachlan now, who will talk a little bit more about the sharp end of ASB practice. And I will fade back into the compliance background where I belong.
Well, compliance is not the background thing, but thank you very much, Dan. That's excellent. Really appreciate that. Some really helpful insights there. And I think there's a few of those points I am definitely going to be picking up on in my in some of my practical considerations section of this presentation. I'm going to be looking at this mainly, as I say, from the basis of my own practical experiences, and the vast majority of these have been in relation to acting on behalf of social housing providers where you know something has happened or you suspect something has happened, but you're trying to find out exactly what, trying to decide whether it's serious enough to look at legal proceedings. That's the context I've usually seen it in. Obviously, it doesn't always come to that. You might just be looking at whether there's anything you can do to assist, trying to signpost to support. You might be uh, just building a general picture because uh, data information is all part of the process of really understanding your tenants, the residents, people in your neighbourhood, working out how you can provide an effective housing service and build sustainable neighbourhoods, which is all part of the social remit of housing associations and local housing authorities. So the issues I'm going to be touching on primarily are going to look at some of those mainly practical considerations, and in particular the point that Dan was referring to right at the very start about the reluctance to share data, reluctance to share information. So just some of the practical considerations I'm going to run through in the time that we have remaining is first what to do in an emergency and some of the legal considerations, just picking up again on some points that Dan referred to. What do you do in terms of dealing with computer says no syndrome, as I like to refer to it, as we should all be hopefully familiar with from the Little Britain sketch. What if you think, well, there's every good reason why the information should be shared, but we're just meeting somebody who's just unreasonably resistant to doing so or feels that their hands are tied when really they aren't. And a couple of considerations from my perspective as looking from a litigation background, as Dan already referred to, which is what about if legal proceedings already in train? What if they're not? And some of the procedural litigation considerations in that regard. So picking up firstly on the point that Dan mentioned about safeguarding, and just to reiterate really what Dan said, which is the ICO guidance itself is very clear. It says in terms, it can be more harmful not to share information. And Dan's obviously already referred to some of those examples. I can speak from testimony of people I'm very close to who have been really frustrated in this instance. I'm aware of one person who was trying to make a referral for child safeguarding to social services and rang up the social services department in question. And the first question, in all seriousness, from the social worker was, do we have the mother's consent to go and speak to her? Which was just so the kind of person that you're having to work with in those circumstances. And I appreciate it can feel like banging your head against a brick wall in many situations. But as Dan did refer to, it's really good to be clear as to the basis on which you're making that safeguarding referral and who you're dealing with. Safeguarding is tended to reference in particular children, young people, and people lacking mental capacity, so vulnerable adults in particular. The reason being is that if somebody is an adult with mental capacity, then it's generally assumed that there's not that same degree of duty to intervene necessarily, whether morally or legally, to try and protect their own welfare. You might want to, in a benevolent sense, but there will be circumstances in which, at the end of the day, an adult with mental capacity may choose, whether wisely or unwisely, that they want to manage on their own. And that is their choice. That's respecting their personal dignity in those circumstances. So the purpose of safeguarding is to protect the interests of someone who's not themselves in a position to do so. And that is the key element to it. So it's very clear about the circumstances when this genuinely arises. So you do have to look at whether the person has the capacity to make decisions. There certainly are could be some blurred lines when you're talking about young people instead of adults, and the point at which they are deemed to have sufficient cognitive ability to make their own decisions. So it is really clear as well to factor in. It's important to factor in the circumstances of the individual you are trying to safeguard. but do be aware of any vulnerability issues. And you may not have a clear picture yet on mental capacity. So try and have when you are communicating that need, you may well need to explain the reasons why you suspect that the person in question lacks mental capacity, why you're seeking to act in their best interests. But we come back to the point that Dan said, there is a whole section on safeguarding in the ICO's guidance. So make sure you have it to hand so that if you are meeting resistance from somebody in a statutory agency capacity, you're saying, I can't share that without consent, or I can't intervene without consent, then you can refer to the ICO safeguarding guidance and say, no, this actually is what it says. I've been in a position where I've had to do that myself, dealing with an education program that was being run for one of my children, where we asked for a report on how it was going. And the person who was running the program says, I can't share that with you because I don't have the consent of your child. I had to point out my child was 5 and was incapable of giving consent, and actually had to copy and paste the wording of the ICO's own guidance on it, send it across to them, at which point they thankfully relented. So sometimes it is just something as basic as that, that you are talking about people who are maybe either through overwhelm or sheer busyness, simply are either not thinking straight or trying to gatekeep a lot of information requests. So if needs be, just try and push a bit harder and see what you can do. And if needs be, speak to someone in a higher authority. On a related note, if you're dealing with someone who's simply saying, I can't share this with you because of GDPR, whatever it might be, whether it's a safeguarding issue or criminal offence data, or details of crime log, whatever it might be. If they're saying, I can't share it with you, I think, as Dan alluded to, the key point is to say they can if they want to, usually. Now, you may well need to tease out the amount that they can share with you, the means by which they can share it with you, the purposes for which they can share it with you, whatever safeguards that might need to be in place. But quite often they probably can. And so if needs be, quote the legislation back at them. And say, this is why I need it. It's because of prospective legal proceedings, or it's necessary for the purpose of obtaining legal advice. Obviously, with some people, you'll still get resistance, but at least it gives you an opportunity to try and break down some barriers. So I referred to Schedule 8 there. That's in relation to special category personal data. As Dan pointed out as well, obviously for criminal offence data, it's Schedule 1, but it's the equivalent paragraph in there. So again, you can get this on legislation.gov.uk. You can access it yourself. You can copy and paste it. It's there freely available for anyone to see. And as I say, there's ICO guidance out there too. So if they think they can't explain to them, well, they can. At least then you halfway to that barrier being taken down. They might then say, I can, but I don't want to. Well, that's a different question. You can then, that's where you might need to up the ante slightly, depending on where we're at in terms of the next steps. Which leads me neatly on to what difference does it make if we're actually in the process of litigation or about to be. So in cases, I'm talking primarily here from the experience of registered providers of social housing and local housing authorities who have retained housing stock. If you are looking to start some kind of enforcement action, a lot of the time it's going to be based in the county court. So that's going to be in the form of an application for an injunction or an application for a possession order. They're the two most commonly used forms of enforcement. Now, obviously, local authorities and police have their own series of enforcement powers, and they're much more likely to have very well established working relationships because there are legal requirements for them to consult with each other in certain circumstances before taking certain forms of enforcement action. So those processes are likely to be already there and in place. So this is where you're talking about outside of criminal sphere. We're talking outside of magistrates. We're looking, except obviously in relation to applications for injunctions against people under 18. But if you're talking about county court, so county court procedures are governed by the civil procedure rules. Again, available online through the Ministry of Justice website. You can go onto them, you can browse around them, you can copy and paste them. The one you really want to have a look at is about disclosure, and that is under Rule 31. And that sets out the County Court's approach to disclosure in civil proceedings. And the County Court has the ability to make orders requiring people to disclose information. And there are two particular circumstances. Well, in total, there's three. The standard disclosure rules apply as between claimant and defendant. So claimant being the landlord, defendant being the tenant, or the defendant in an injunction proceedings. Obviously, you have standard procedures for them to make each other aware of the evidence against them or in favour of them. We're talking about circumstances we go slightly outside the ordinary. There's two main ones. One is against disclosure against non-parties. So let's say I'm a housing association, I'm seeking possession against a tenant, and I want to know full details, chapter and verse, as to what information is held by the local police in relation to a serious incident which occurred, which was referred into in the notice seeking possession and in the particular claim. So but I've asked the police, let's say, for that information. The police aren't willing to disclose it. They say we're not willing to provide that. Obviously, the matter of the conviction is an issue of public record, but the circumstances behind it and what exactly went on may not be, and the full intel might be still confidential information. They're not willing to share that information with you. So under these circumstances, under Rule 31.17, you can make an application against a non-party for disclosure of information that they have, which would assist in the administration of justice in relation to your proceedings. It may, and the other question of that is, obviously in civil litigation, it's quite likely that solicitors are going to be involved. So who's going to pay the costs of you making that application to court? It may be something, depending on the nature of the relationship you have with that police authority, you might want to suggest to them that if they unreasonably withhold this information when they could disclose it if they wanted to, and you're going to be able to get a court order to compel them to disclose it, then should they be contributing towards your legal costs as a result? That might be enough in and of itself to try and shake things up a little bit. I have had a case along similar lines, actually, where I was sat in county court, and because we had some issues with the police being very reluctant to share information and their intelligence around a particular series of ASB complaints, we tactically invited them to the court case to sit in the public gallery, which worked a treat, because when the district judge inevitably complained to me, Mr. McLean, why on earth is there such sparse information in your client's witness evidence about these incidents which have all occurred? I explained to the judge that this was due to a lack of cooperation from the police in providing the data that we had requested. The fully uniformed police officer who sat at the back of the courtroom severely regretted having come along to court that morning, but it worked perfectly, because they went away with a flea in their ear from the judge, who reported it back to their supervisors, and we got a bit more cooperation from them going forward. That's all I need to say, really. So that deals with third-party disclosure applications. Obviously, it's something which I'm not going to go into the full detail of how it works due to the time constraints, but just to let you know, it does exist. What if we haven't actually started the proceedings yet? Well, this can be a little bit trickier, because you can't apply for pre-action third-party disclosure. So you can apply against a proposed defendant, so that you can say, well, I believe you have information which would assist me in deciding how to bring this claim. So you can apply against the defendant. You can't apply against someone who isn't likely to be a defendant themselves. That's just one of the quirks of the civil procedure rules, unfortunately. So it begs the question, well, how do you start a claim if you don't know what evidence there might be? One thing that has occurred to me is, well, as a bare minimum, unless the situation is particularly urgent, you need to go ex parte, or the risk is that if you start proceedings, then without an injunction being in place, then the defendant might engage in retributive action. Then you might be able to make a pre-action disclosure against your tenant or the proposed defendant in the litigation if they are in possession of information around, for example, their summons to court, to the magistrates or to the Crown Court. That is information which I'm pretty sure they'll have an email or a letter from their solicitors, or even if nothing else from the court service, as to the nature of the proceedings against them. Not all communications from a solicitor are necessarily going to be privileged. They're only privileged if they're going to be for the purposes of providing advice. So if it's simply a case of, well, here's an appointment letter for you to come to your court case, then that might be disclosable. We'll have to wait and see. But the issue is that it's going to be a fiddling, expensive process. It's something you'd only really want to use in the most serious cases. Other than that, sometimes there just simply are limits to what you can achieve without a degree of goodwill from the statutory agencies involved. And so in certain circumstances, there will be limits that you won't be able to do necessarily everything you want to be able to do. At least once you've managed to get some proceedings off the ground, if there's enough to go on, then you might be able to make a third-party disclosure application at that point, which then might bulk out your case and improve the prospects of success. And then just to finish off, in terms of therefore, what really is going to make the big difference is finding something that works well. And as Dan mentioned before, a key thing is going to be ultimately relationships. You're going to have to find a way to make connections with people who do have the ability to get you that information, get you that data. And then once you've made that connection, established that relationship, to really build on it. I recall many years ago, in my early years of practice, I was a member of a monthly information sharing meeting. Worked really well. We had representatives of the local police, we had a local social worker, we had antisocial behaviour officers and managers from all the main housing associations in that area. And we would meet on a monthly or bi-monthly basis. And it was a case, we minute all the discussions that took place so that we knew what information had been shared and disclosed. But it was an opportunity to coordinate and discuss circumstances which were arising on particular neighbourhoods. Oh, apologies, sounds like there's a test going on there for our fire alarm. It was a really good way of generating those relationships and making sure that that information could flow freely. Really crucial to that, though, was having a really clear data sharing agreement with policies and procedures in place, so that anything that's discussed informally could then be followed up in writing if needed. Ultimately, can you find a way to speak to the right people? If needs be, there might be circumstances, hopefully when we come to it, we might have to put in a formal complaint. Sometimes that's the nature of the beast. Sometimes you will necessarily have to put in a formal complaint, escalate things to a manager who's maybe more willing to deal with it. Building strategic relationships which enable you to find those mutual interests and explain the benefits which come from you having effective access to information is going to be really key. So that really concludes the formal part of our presentation today. Appreciate we've now pretty much hit the 1 hour time estimate for this, but if anyone has to go, then we understand. But if anyone does have any questions that they want to raise, Dan and I can hang on for a few minutes and see if there's anything else that we can provide some further advice on, or further views on at any rate. Just end this presentation here.
It would appear, Lachlan, we have solved the data sharing. This is tremendous. Interagency cooperation will now proceed smoothly in all quarters.
Yeah, indeed. Appreciate that. There doesn't seem to be any nobody's raised any Q&A while we've been on. I understand people will need to potentially make their way on to further meetings and so forth. If you do have any queries that come to mind afterwards, then drop an email through to our business development team. They'll be happy to pass them on, and we'll see if there's anything further we can do to assist. In the meantime, I hope you found today's session useful, and hope you have a good rest of the day.
Thanks for your time.